Good afternoon, and welcome to the Employer Link webinar series presented by McAfee and Taft. My name is Brad Neese, Managing Editor of Employer Link. Nearly 4 years after the Affordable Care Act was signed into law, the IRS has finally released its much-anticipated final regulations on the Act's so-called play or pay mandate. Considered one of the key components of healthcare reform, this mandate requires certain employers to either offer affordable minimum value health coverage to their employees and dependents or pay certain penalties. Since the final rules were issued last month, our attorneys have been busy reviewing and analyzing the 227 pages of complex rules. Here today to help make sense of those regulations so that you can be prepared for the upcoming benefit plan year are McAfee and Taft attorneys Brandon Long and John Papahronis. Joining them is Teah Corley, CEO of PremierSource, a leading benefits consulting firm. Before we get started, though, there are a few items I'd like to point out. Employer Link 2014, McAfee and Taft's annual Labor, Employment, and Employee Benefits Seminar, is coming April 16th in Oklahoma City and April 17th in Tulsa. This year's theme is In Compliance Out of Court, with a focus on helping arm employers with the knowledge and practical advice they need to comply with the significant number of state and federal laws that govern the workplace, thereby preventing or minimizing costly and time-consuming litigation, investigations, and audits. The morning session will include 6 fast-paced, information-packed presentations by the Labor and Employment Group covering key compliance issues commonly encountered during the pre-employment, employment, and post-termination phases. The afternoon session will feature 3 presentations by the Employee Benefits Group providing the latest updates and must-know guidance concerning healthcare reform, as well as company-sponsored qualified retirement and health and welfare plans. For more details and to register, go to employerlink.com/seminar. Second, this program has been submitted for approval of 1 hour of general recertification credit through the HR Certification Institute. For those who pre-registered for HRCI credit, we will send a follow-up email as soon as we get final approval from HRCI that will include program details about today's webinar for recertification submission. Also, on your screen just below the slide presentation area, you should see a tab called Supporting Material, and that will allow you to download a PDF version of today's presentation materials, and those materials are also available on the webinar resource page at employerlink.com. As I mentioned earlier, our presenters today are McAfee and Taft attorneys Brandon Long and John Papahronis, and they are joined by special guest Teah Corley with PremierSource. Brandon and John are employee benefits attorneys who work with employers of all sizes in designing, analyzing, and implementing cost containment strategies for company-sponsored health and wellness plans. Much of their work these past 4 years has been dedicated to helping employers effectively plan and prepare for healthcare reform. Their areas of expertise also extend to retirement plan design, executive compensation, COBRA and HIPAA compliance, and the representation of clients in audits and investigations by the IRS and U.S. Department of Labor. Teah is an employee benefits and risk management consultant and CEO of PremierSource. PremierSource has been at the forefront of helping employers implement cost-saving strategies by digging deep into company health plan data and analytics to identify those areas which significantly impact plan performance and the bottom line. So with those introductions, I'll now turn it over to Brandon.
Hi, everyone. Thank you so much for participating today. We're very grateful for your interest and your time. We kind of had this lull after the first of the year where it seemed like things were kind of quiet. We were kind of catching our breath, and the regulatory activity had slowed down a little bit. And then comes the month of February, and we've had an avalanche of very complex rules. Some are more complicated than they need to be, but we had the player pay rules, which we're discussing today, on February the 10th, and then a few weeks later we had the 90-day waiting period rules, and then we've also had more recently rules coming out on employer reporting requirements, in terms of who you offer coverage to and who you don't. Last week, the government issued some regulatory guidance on the reinsurance fee, and we anticipate more guidance coming. So today we're trying to not overwhelm you folks or ourselves, frankly, and trying to break this into pieces for you. And today's we're going to focus on the player pay rules, which are probably the most anticipated rules that we've been kind of waiting for a while. And we'll talk a little bit about the 90-day waiting period rules, but let's jump right in. The first slide, we kind of basic concepts here. These new rules that came out on February the 10th did not change the definition of a full-time employee. A full-time employee is still someone who works on average 30 hours a week. Also not changed is the scheme, the penalty scheme, which is there are two penalties. You can't pay both. They're mutually exclusive. The $2,000 penalty, and this is the penalty, what we call the no coverage penalty or the sledgehammer. This is the penalty that you pay if you fail to offer coverage to 95% of your full-time employees. So if you don't offer coverage at all, you pay the $2,000 penalty times the number of your full-time employees less 30. And we're going to talk, they've changed some of those, what I've just said, a little bit in these rules. The other penalty and it's important to keep these two separate, is the penalty that you can get hit with if you offer coverage, but the coverage that you offer is not very good. The coverage is either unaffordable or it fails to provide minimum value. And that penalty is the $3,000 penalty. And that's a much smaller penalty. That's why we call it the tack hammer, because it is not counted based on your total employee population. It's only the number of those employees who go to the exchange and receive subsidized coverage. Okay, so we're going to jump right in here and talk about some of the what is new first, and then we're going to kind of talk about the measuring period rules and some of those things. But before we do, I thought it would be helpful for Teah to maybe talk practically for a second and think about strategies and in terms of maybe looking at all of this stuff. Maybe it's not as complex as you think it is, and I want her on the consulting side to just kind of weigh in and tell us some thoughts.
Sure. Yeah, I think, again, there's a real tendency in all of this. It is very complex, and there's a lot going on with it. But I think there's a tendency for employers to look at this and immediately, because we're also compliance-driven, that we're focused on complying with the rules, immediately jumping to making sure we don't hit the $2,000 penalty. Nobody wants to hit that. But there are some strategies to look at versus just including everybody in your current benefits. Maybe looking at some alternatives, maybe minimum value plans that could be implemented, and really just modeling that out to do the dollar cost benefit analysis. So certainly nobody wants to hit the no coverage penalty, but even for the $3,000 penalty for affordability or minimum value, they again just want to model that out and weigh the differences. There could be opportunities there to save, really even by paying the penalties. And then the practical application of the $3,000 penalty and what that looks like. A member would have to go to the exchange and actually apply for that before that penalty kicks in. And I think employers just need to be aware that, again, these penalties may or may not apply. So really just model it out and do the dollar cost benefits and not get so weighted down in just the compliance aspects alone.
Thanks, Teah. So, one of the new provisions in these final regs is that there is relief for 2015 for large employers and a large employer, only large employers, as you all remember, only a large employer, and that is an employer with 50 or more full-time equivalents, I'll call them, is subject to the player pay rules. And for 2015, they gave us a nice new wrinkle that says if you have between 50 and 99 full-time equivalents, you are not subject to the A or the either penalty for 2015. And now, this, if you have for those in our audience that have a non-calendar year plan year, if let's say it's a July 1, 15 to June 30 of 16 plan year, that would be the first plan year beginning in 2015. The relief would also extend to you through the months in 2016. So if you have 50 to 99 full-time equivalents, you can take advantage of this kind of transition relief so that you don't have to offer coverage in 2015 at all and worry about paying these penalties. Now, the thing that I would say to you is the calculation of how many employees you have, full-time employees and full-time equivalents, which is critical for determining whether you fall in the 50 to 99 range. It's not a complex analysis, but it's also not real easy. So if you're going to, kind of march down the road and say we're not complying at all because we've got a waiver because we only have 50 to 99 full-time equivalents, you want to be real sure about the way you're calculating that, and we or your lawyers or consultants should be helping you kind of figure that out and drill it down just to make sure, because you don't want any surprises later down the road. So one of the requirements for this transition piece, you have at least 50 full-time employees but fewer than 100. Between February 9th of 2014, which is the day before these rules were issued, and the end of this year, you don't reduce your workforce to satisfy the 50 to 99. In other words, if you have 125 full-time employees now, you don't fire 26 of them to bring you down below 100 before the end of 14. That won't work. You also cannot eliminate or materially reduce the coverage that you offered as of the day these regs were issued, or the day before on February the 9th. So basically, if you can't tinker around with the existing coverage that you have, they don't want people reducing their employee count or cutting health coverage in order to take advantage of this rule. This is really designed for those folks that truly have, as of right now, 50 to 99 employees and need a little extra time. And then you're also going to have to certify. There's the fourth and final requirement is that you have to certify on a form that you meet those requirements. And, the indication in the player pay regs was that certification would be a part of the employee reporting process, which are the regs that just came out even more recently. And those regs, by the way, folks, I know we're talking about player pay rules, but the employee reporting rules are something you all should be thinking about and working on right now. We don't want to wait until the end of 2015 I would, start looking at those requirements right now and getting your consultants and lawyers to help you with that as well. The next transition piece, and that's the second bullet on your slide, is that there's relief in 2015 for large employers. For those of you that have 100 or more full-time equivalents, they gave us a nice new wrinkle that said, before I told you in the slide before, I said you have to offer coverage to 95% of your full-time employees and their dependents to avoid the big penalty, the $2,000 one. Well, for 2015, the transition guidance that's in these regs says as long as you offer coverage to 70% of your full-time employees and their dependents, you get off the hook of the $2,000 penalty. Now, we're not going to spend a lot of time in this because it can be a little confusing, but just know that if you offer coverage to 70% of your full-time employees and their dependents and you avoid the $2,000 penalty, you could still get hit with the $3,000 penalty, not only for the 30% who you're not offering coverage to, but also to the 70% if the coverage that you offer fails to provide minimum value and it's unaffordable. So if you have 100 or more employees, you're not off the hook completely. It just allows you to avoid the biggest piece of the penalty potential there. They also have, and my partner John is going to talk about this concept in greater detail. There's a new monthly measurement period concept in these final regulations. I'll let John talk about that. There's a new definition of a seasonal employee, or there's a little more clarity. And this is important we have a lot of folks that have casinos, or they have cities that have swimming pools, those kinds of things. A seasonal employee is now defined as someone who works on a customary annual basis 6 months or less. So we need to make sure when you're talking about who you have as a seasonal employee, you need to make sure that those folks work 6 months or less on a customary annual basis before you can classify them that way. And that has significance for reasons we'll talk about later. And then there are new factors to determine if a classification of a new employee as not full-time. In other words, John starts working for you today, and you say, okay, is John going to work 30 hours or more for me on average a week? And if the answer to that question is no, I don't think he is, and so I'm going to treat him as a new employee and measure his hours prospectively before I start offering him coverage. There are factors that the IRS wants you to consider, and that the IRS will look at to determine if a new employee is, in fact, reasonably classified as not full-time. And John's going to cover those in greater detail. There's a new rule for determining whether a rehired employee can be treated as a new employee. This is significant, folks, because under the proposed regulations, if someone is if you're using these measuring period rules, which generally state that you're going to look at someone's hours, you're going to measure their hours over a measurement period, kind of on a look-back basis, and determine whether they to offer them coverage or not prospectively through a stability period. And we're going to talk about these rules in more detail. But the rehire rules now say, and this is new, that if someone leaves for more than 13 consecutive weeks, you can treat them as a new hire, and basically you can start measuring their hours all over again. And what this means is, let's say, John starts working for you, you measure his hours let's say you've been measuring his hours for 4 months, he's a new employee, he's part-time, you're going to measure his hours, and he's 4 months into his employment, and he leaves. Well, if he's gone for more than 13 weeks, when he comes back, you could treat him as if he just came back to work for you, and you could start measuring his hours on a fresh basis all over again. If he's not gone for more than 13 consecutive weeks, you have to basically continue measuring his hours over the same period that you were measuring his hours before he left, and you would give him, unless it's special leave like jury duty or USERA or FMLA leave, unpaid, all of those unpaid, then unless it's one of those unpaid categories, you would give him 0 hours for the period of time, and then that he was gone, and then continue measuring his hours as he moves forward. Now, if you're an educational institution, there's a wrinkle here. The regulations, if you're an employer that is an educational institution, the rehire rule is not 13 weeks. It's a 26-week consecutive week period, so it's a little bit longer before you can treat someone as a new hire. That's new. There's a new clarification that a dependent does not include foster children or stepchildren. There are new special rules for adjunct professors, certain categories of employees like airline employees and on-call employees. And these special rules go into when you're measuring hours of an employee that falls into these categories, how many hours how do you count their hours? And what they've said is, if you're an educational institution and you employ adjunct professors, you have to use a reasonable method to calculate their hours. And one of the reasonable methods that they've identified, not the only, but one of the reasonable methods they've identified for us is they say you give an adjunct professor 2.25 hours credit for every hour that they are set to teach, plus any other hours that you require them to attend meetings or have in-office hours. So there are some rules like that, very special. Not going to spend a lot of time on those. On-call employees, we get this question occasionally, is how do I count the hours of folks that are on call? And the answer is an hour of service under the rules, and most of you will remember this, is defined as each hour for which you are paid or entitled to payment. So if you have an employee who is on call and they are entitled to payment during the period when they're on call, you've got to count those hours. If you require them to be on call at your premises, you got to count those hours, even if they're not paid for them. So there's some kind of special rules with special categories of employees. If you have folks that fall into any of those categories, I'd be glad to talk to you specifically about your situation. There's new transition relief if you don't currently offer dependent coverage that says you don't have to offer dependent coverage in 2015. This only works if you don't currently offer dependent coverage. Most of our clients, I think, do offer some level of dependent coverage, and so I think for most people, this transition rule will not be very helpful. There's transition relief for non-calendar year plans. If you have a non-calendar year plan, these rules, this is one of those where the rules are way harder than they need to be, and you would really send me an email or call me, and I can help you walk through those, because the transition relief for a non-calendar year plan is fairly complex, I think.
And then, Brandon, I guess one other point there is you're not able to change your plan year to a later date after February 9th, or you could disqualify for the transition as well, right?
That's absolutely right. That's a great point. So, okay. There's new transition relief for an employer who first becomes a large employer. Folks, remember again that a large employer, applicable large employer, is someone who employs 50 or more full-time employees and full-time equivalents. Let's pretend that XYZ Corporation first employs 50 employees in 2015, so that it would first be a large employer for the 2016 calendar year. So It's a look-back calculation. If we're looking to determine whether this XYZ company has to offer coverage to its employees in 2016, we're counting the hours or the number of their employees in 2015. And this new rule says basically if you first become a large employer, in my example, XYZ Corporation first is a large employer for 2016 because it had more than 50 employees in 2015. It has a pass for January, February, and March of 2016, which is the first year that it's a large employer, as long as it offers affordable minimum value coverage by April 1 of 2016, it's off the hook for all penalties for January, February, March of that year. New clarification that excludes volunteer hours for governments and tax-exempt entities. And this would, and they've kind of, what happened here is some governments, some tax-exempt entities said, hey, look, we got volunteers that are not employees, but we reimburse them for expenses, and we might give them a stipend. And they wanted to kind of carve those folks out so that we don't discourage people from volunteering or for using volunteers. One thing I might mention for all of our government employers and our Indian tribes that are listening, one of the new things that are maybe not new, but there's a lot more clarity in these final rules and in some of the guidance issued with the final rules that basically makes it crystal clear that governmental entities are subject to these player pay rules, including Indian tribal governments. A lot of our tribal employers, that have tribal members as employees who are themselves not subject to the individual mandate. There's lots of it wasn't clear as to whether they were subject to the player pay rules, and this new guidance has made it crystal clear going forward. New special rules for temporary staffing employers. I saw on our attendee list we do have some staffing employers listening in. In terms of when John is talking about when you hire someone new and you're trying to figure out, are they full-time so that I have to offer them coverage right away, or are they a variable hour employee or a part-time employee that I can measure their hours on a prospective basis before I offer them coverage? There's additional factors that are going to be considered by, if you're a temporary staffing agency, when you look at that calculation or when you make that decision, including, for example, whether employees in the same position have the right to reject their temporary placements. So there are a handful of very specific rules for temporary staffing employers that you would want to be aware of, and I'll be glad to send those to you also. New explanation in terms of how the penalties will work. The IRS will contact employers after the fact, after the individual files their tax return claiming the credit. And then there will be a process where you as an employer, if an employee files and claims, hey, look, I was entitled to a credit for this year because my employer failed to offer me affordable minimum value coverage, you will have the ability to protest that. They've indicated additional guidance will be forthcoming on that process. And then there is lastly, before I turn it over to John, there's a new special one-time measurement period allowed in 2014. I'm going to stop right there. I'm going to say it one more time. There's a new special one-time measurement period allowed for this year for the 2015 stability period. And this special one-time measurement period says you're allowed to measure people's hours over a 6-month period and then use the hours that they work and the determination of whether they're full-time or not during that 6-month measurement period to lock them in either as a full-time employee or not as a full-time employee for all of 2015, okay? So this is special because typically you're not allowed to measure someone's hours over a 6-month period and then lock them in for 12. This new special one-time rule is similar to the rule they issued last year in proposed guidance. The key here, you folks, is that you're going to have to start this measurement period. If you want to do this, you're going to want to, if you have part-time employees right now and or folks that you're not sure if they're going to work full-time, and you want to measure their hours right now for purposes of 2015, and I would be talking mostly to my employer groups that have 100 or more full-time employees, you're going to want to start measuring their hours no later than July 1, 2014. My recommendation, just practically, folks, is I would start measuring people's hours. Here we are. This is March the 13th. I would try to start measuring your part-time employees' hours as of April 15, 2014, i.e. a month from now, through October 14 of 2014. So we're, again, measure hours April 15 of this year through October 14 of this year. Then you would use the rest of the year through the December 31 of this year to get them enrolled as kind of your administrative period. And then assuming they average 30 hours a week during this 6-month measuring period, and then you would lock them in for all of 2015. Similarly, if you measure their hours over this period, April 15 of 14 through October 14 of 2014, and you determine they do not average 30 hours a week during that 6-month period, you would not offer them coverage for all of 2015, regardless if their hours fluctuate above 30 hours during 2015. Teah?
And yeah, Brandon, I think just before we move on to the next section, pointing out, you're mentioning the relief in 2015 at the 70% where they only have to offer that coverage, but that reverts back in 2016. I just want to make sure we made that distinction so that as they're planning for this, they're not basing everything on that 70%.
Absolutely, because she's exactly right. Is starting in 2016, that 70% transition standard goes away, and we go back to the 95% standard that we mentioned on the first slide. John's going to talk about whether how you determine if you're a large employer.
Thanks, Brandon. As you know, there's several determinations that an employer has to make in applying the player pay regulations and the rules. Probably the threshold question is your organization, is your company a large employer? Because if it's not a large employer, then you don't have to go to the next step about implementing the actual player pay requirements. And since the player pay requirements become effective in 2015, now's the time to address the question of whether you're an applicable large employer. The basic rule for whether you're a large employer is whether you have at least an average of 50 full-time employees, including your full-time equivalent, during the preceding calendar year. And as Brandon mentioned, one of the new things, one of the transition rules is that 50 is up to 100 for this first year. So that's a 1-year special rule. Now, when you're determining who are full-time employees, that includes full-time equivalents, and that means that you take any part-time employees and you aggregate them together and basically lump them together to determine how many full-time equivalents you get out of that block of part-time employees. So that goes into the number of employees for that determination. Now, those full-time equivalents are not included. Say you are an applicable large employer and you do have to comply with player pay. Those full-time equivalents are not employees that you necessarily have to cover under your plan. They just go into the determination of whether you're a large employer. There is an exception in that determination for seasonal workers. They become excluded from your determination. And also want to point out that for 2014, there's a special rule that you can take a minimum at least 6 consecutive months for determining whether you have 50 employees rather than the entire year. And so that's a special rule that you can take into account for 2014 for purposes of determining what your 2015 status is. And so that could be really helpful. For example, if you wanted to take the first 6 months of 2014 rather than the last 6 months, that could be really helpful. There is also a rule in the final regulations that addresses what if this is your first year in business, and in that case, the IRS has said that you determine what your reasonable expectations are for the number of employees that you're going to have in your first year of operation, and that will determine whether you're a large employer or not. Next point is when you're determining your large employer status, that determination is made on a control group basis. And that means that all companies or entities that are commonly controlled or commonly owned go into the calculation of how many employees that you have. You're treated as one, quote, employer for that purpose. And so that's a really important point because some organizations, they treat their different affiliates as completely separate for operational purposes, and they really don't think of themselves as one one group, but for purposes of this determination, you have to look at the entire group. An example of this is, for example, if Company X owns 100% of two other subsidiaries, and one subsidiary has 40 full-time employees, the other has 60, the entire group, since it's all commonly controlled, the entire group has at least 100 full-time employees and is considered to be a full-time employee, a large employer. So the bottom line on that is it's really important to make a determination for your control group. What is your control group, and how many employees are in each of those entities that are in your control group? The determination of what's in your control group is kind of a technical determination, and is something that you need to look at. There's some special rules that apply. It's just in general, at least 80% or more common ownership determines common control. Okay, the next kind of decision point to make in applying the player pay rules is identifying who's a full-time employee. And in general, the basic rule is that if an employee averages 30 hours or more per week, or 130 hours per calendar month, they're considered to be a full-time employee. There are two ways of identifying who is a full-time employee, and under the new regulations, they've added the monthly measurement period, which we'll talk about in a minute, and of course, there's also the look-back measurement period. For hourly employees, the number of hours that you determine to determine whether they're full-time is based on their actual hours worked. And the hour of service is any hour that they're paid or entitled to payment, and that's, of course, that's also counted for any member of their control group. So if you have an employee that works for one member of the control group and then crosses over and also works for another member of the control group, you aggregate those hours all together. When we talk about paid leave, or each hour that's paid, that includes any paid leave for vacation, holidays, sickness, disability, leave of absence. As long as it's paid, then it's counted for those hours. For non-hourly employees, hours are based on, you can either use their actual hours, or you can also use other equivalency bases. For example, 1 hour, if an employee works 1 hour per day, a salaried employee works 1 hour per day, then you could credit them for 8 hours. Or if they're a salaried employee and they're working 1 hour, you can count them for 40 hours a week. So there are some equivalency rules that you can apply to determine how to treat salaried employees. The final regulations also, as Brandon mentioned, they have some new standards for addressing employees that have unique hours, like commissioned salespeople, on-call hours. As Brandon mentioned, bona fide volunteer hours don't count. And I just want to point out, when the IRS did these final regulations, they looked at, but they did not make any special rules for any short-term or high-turnover employees. So, like in the restaurant business, if you have employees that turn over very high, there's no special rules that are address that. There's also no exception for student interns. If a student intern is working and getting paid, then they have to be counted the same as any other employee. A new concept that's been introduced in these final regulations is the what's called the monthly measurement period, and that's for use when you're not using the look-back method for determination of the pay or play status. What this means is that a full-time status is determined on a monthly basis. You count their hours during the particular month and determine whether they're full-time, just on a month-to-month basis. If an employee is determined to be full-time, then the rule is that they're to be provided coverage within 3 months, the first day of the fourth calendar month following their date of hire. There is on using this new monthly measurement period. We've looked at this, Brandon and I and the others in the office. It's not clear to us. It seems to us that the best planning method is still the look-back method. We're really not sure how much the monthly measurement period is going to be used, but nevertheless, that's what these new regulations provide.
John, I think that for those employers that only have just a few part-time employees, maybe that scenario, but other than that, we really don't see a practical use.
I think that's exactly right, Brandon. As Brandon mentioned in the opening, there's some new rules on rehires and when you can treat them as a new hire. In the preliminary regulations, they had the break in service set at 26 weeks. They've reduced it to 13 consecutive weeks. So that's a positive change. And then, as we said, they've got an employee has to be offered coverage by the first month after they've resumed service employment. Okay, what happens if an employee changes status? What if an employee changes status from seasonal to non-seasonal, part-time to full-time, variable to full-time? What do you do in those circumstances? Well, then what the regulations say is that you treat the employee as a full-time employee on the first day, the fourth month following the change, and so they've got to be offered coverage. So in this example, the employer hires Brandon on January 1, 2016. He's part-time for a period of time. Then on January 1st of 2017, he's promoted to full-time. So for January through March of 2017, he meets all the conditions for eligibility. That's considered to be his waiting period, so he has to be offered coverage effective April 1st of 2017. Brandon will now take a look at or talk about the look-back measurement period.
Folks, the look-back concepts are not a lot of changes from last year. I think it's helpful just to think about the different categories of employees, and this slide kind of summarizes all of those. Ongoing employees are those employees who have worked for you for a while. That's technically defined as someone who's worked for you for a full measurement period. So if you use, for your folks that have been with you a while, if you use a standard measuring period of, let's say, October of 2014 to October of 2015, if that's a measuring period you use, it would be someone employed during the entire 12-month period. New full-time employees are folks, you hire John, you know John's going to work 30 hours a week. You have to offer John coverage by the first day of the fourth month following his date of hire. There's no reason to measure hours. Sometimes some of the questions we get about measuring rules that people ask about full-time employees, if you know someone is full-time when you hire them, there's no reason to measure their hours. You need to offer them coverage by the first day of the fourth month following their date of hire. New wrinkle in these regs, the definition of a part-time employee. This is someone you know is not going to work 30 hours a week. They are treated the same as a variable hour employee. The variable hour employee concept and definition was in the proposed regs. It hasn't changed. That's just someone, when you hire them, you're not sure if they're going to work 30 hours a week. Again, a part-time employee is treated the same as a variable hour employee. And likewise, a seasonal employee, I told you earlier that if someone works on a customary annual basis 6 months or less, the significance of that is you're allowed to measure their hours over a subsequent period of time, even if you think during the season that they work, they're going to work more than 40 hours a week. So full-time employees, you offer coverage by the first day of the fourth month following date of hire. Part-time employees, new variable hour employees, new seasonal employees, you need to measure their hours over a measuring period starting after their date of hire.
And Brandon, I think as a practical matter too, if the employers are out there kind of panicked about how they're going to keep up with all this and track it, the marketplace is finally starting to catch up with some of this, and there are some tools out there that will allow them either to work within their payroll system or alongside it to track this and really help out with that. So we can provide a list of some of those resources if they need it.
That's great. Thanks, Teah. The concept on these look-back rules, again, is that you're looking back over a period of time and measuring hours to determine if an employee averages 30 hours or more a week. Keep in mind the ongoing employee concept these are folks that have worked for you for some time, and the measuring period for an ongoing employee has to be at least 3 months, but not more than 12 consecutive months long. Practically, folks, we recommend if you have a calendar year plan year, an October 15 of one year to October 14 of the next year measuring period, followed by the administrative period through the end of that year, and then locking them in for a full 12-month stability period that coincides with your plan year. So you're measuring hours over a 12-month period for these ongoing employees. If someone averages 30 hours a week during that period, you're going to offer them coverage for the entire subsequent year. If they don't average 30 hours a week during that 12-month measurement period, you won't offer them coverage during the entire subsequent 12-month stability period. There are different categories. The regulations, the IRS does not like you treating groups of people differently. The only kinds of people that you can measure differently, you can use differing measuring periods, are these four. If you have an hourly population and a salaried population, and you want to, for example, if you want to use a monthly measurement period rule for your hourly employee, and if you want to use a look back for your salaried, that's permissible. But beyond that, I get a lot of questions about special categories of people. You cannot treat categories of folks differently. You need to kind of measure them all the same.
And Brandon, one exception is the controlled groups, right? Can they use different methods for one controlled group member versus another?
That's right. Okay, just as an example, employer Z is a large employer. Employer Z decides to use the standard measuring period of October 15, let's pretend, of 2014 through October 14 of 2015. And then an administrative period from October 15 of 2015 through the end of the year of 12/31 of 15. If Brandon averaged 30 hours a week during that measuring period, you would use October 15 to December 31 of the subsequent admin period to get him enrolled, and then for all of 2016, you would offer him coverage. And actually, I skipped ahead, but what I just described is already covered in this slide.
Okay, how do we determine when you have a new employee that you hire, how do you determine whether they're a full-time employee? The final regulations address that. They say that it depends on the employer's reasonable expectations as to how many hours the employee is going to work based on his status at the start date. Usually that's obvious, but sometimes it's not obvious. The IRS has said you make that determination based on the facts and circumstances at the time, but it gives us some factors to consider in making that determination. So the factors they've listed are the three factors listed on the slide. Is the employee replacing another full-time employee? If that's the case, that indicates that they're a full-time employee. If the hours of the new employee are the same as other full-time employees in comparable positions, that's another indication. How was a job advertised or communicated to the employee when he was hired? That's another indication. And again, we said this before, if it's a new full-time employee, you've got to offer that employee minimum value coverage by the first day of the fourth month following the date of hire. There's the rule about the first day of the fourth month is slightly different from the eligibility rule of 90 days that a person has to be made eligible and enter the plan after 90 days. There could be a slight difference in that. So we would recommend using the earliest of course. And since we're talking about a rule of when they have to enter for purposes of the player pay, and then there's also the rule for purposes of eligibility, those are technically two separate rules, and they each have their own penalty. So if you don't get someone in at the right time, there's a potential to have two penalties assessed under these player pay regulations.
And then just practically, John and I were kind of kicking this around before we started. Practically what that means, I think, is that if John starts working for you and you know he's a full-time employee, you need to offer John coverage. He needs to effectively have coverage by the 90th day following his date of hire.
So that's exactly right. That would be the earlier of 90 days or the first day of the fourth month. That's exactly right. If in order to apply the look-back method, the regulations have guidelines on establishing the look-back period with respect to new part-time employees, variable hour employees, and seasonal employees. And this is just further implementation of the look-back period. The initial measurement period has to be at least 3, but not more than 12 consecutive months, beginning on the date of hire. The stability period has to be at least 6 consecutive months. And if we turn to the next slide, there are 2 special rules, and even though at the outset we told you we're going to try to keep this simple, this is where it really starts getting complicated. If the employee is determined not to average at 30 hours, then the stability period can't be more than 1 month longer than the initial measurement period, and must not extend beyond the remainder of the first standard measurement period. So it's a really complicated thing. I don't want to get bogged down in this, but you can see that if you need to apply these special rules very carefully so that you don't exceed the time periods. We have an example of if an employee experiences a change in status during the initial measurement period, and the employer knows that the employee will average more than 30 hours a week. Again, we've said this before, the employer has to offer coverage on the first day of the fourth month following his change in status. So it's kind of the same principle. As you can see, you got to offer coverage by the first day of the fourth month following the change in status. It's really the same principle. And finally, we have one last example. And again, this is getting kind of into the weeds a little bit. An employer uses 11 months initial measurement period, followed by a 2-month partial month administrative period, and then there's a 12-month stability period. So Robert is hired on May 10th, 2015. His initial measurement period runs from January 1, 2015 through April 30th, 2016. And he's got 30 hours per week during that period. So the administrative period would end on June 30th, 2016, and there would be a penalty if he's not offered coverage for the stability period beginning July 1, 2016 through June 30, 2017. Again, the examples get a little complicated. Don't want to get bogged down in that, but that kind of gives you a gist of how that works.
One of the reasons I like John's example here, though, is that I think there's all sorts of ways you can structure this. My advice on new hires is that you start measuring their hours on the first of the month following their date of hire over an 11-month period, exactly what John put in this example. You use 2 months after that 11-month period ends, assuming they average 30 hours. Use that 2-month subsequent period to get them enrolled. And then you lock them in for 12 months after that. So the reason that John put this example in is that practically, this is exactly what we're recommending to people to try to simplify these rules, is that you start measuring a new variable hour or new part-time employee's hours on the first of the month following date of hire, and then you use 2 months after that to get them enrolled, get them all their enrollment materials, and you lock them in for the 12 months that follow, the stability period that follows. So this example practically is exactly the way that we recommend you handle your new variable hour and new part-time employees. Okay. The waiting period rules were issued, these player pay rules were issued on the 10th, and then 10 days later they issued the waiting period rules. And it's a little... These rules are not incredibly complex, but there's some kind of wrinkles here that we want to just spend a second at talking about. The waiting period is defined basically as the period of time that passes when someone is eligible for coverage, the period of time after that before coverage is actually effective. So Brandon goes to work for you. I'm full-time. You know I'm full-time. You can't make me wait more than 90 days before my coverage is effective, okay? One of the, in the proposed rules that were issued previously, a lot of commentators asked the government to say, okay, a lot of our plans have a first of the month following 90 days. They have that kind of a waiting period structure in their plan, and just for administrative ease, government, let us keep that system in place. And the government, and they said no. So what I see this time of year, Teah and I and John have been starting to review a lot of plan documents for 2014, and I still am seeing in your plan documents it'll say things like first of the month following 3 months after you're hired, or a 3-month waiting period. 3 months can be, in some scenarios, more than 90 days. You need to always make sure that your waiting period does not exceed 90 days. It's not the 91st day that you get them in. You need to get them in on the 90th day, in my opinion, to be safe. And so there's what these regs said. I mean, everybody that's listening, that deals with benefits is probably like, duh, we've known that for, long time now, that your waiting period can't exceed 90 days. Well, it's still in the document, so you need to look for it. And then what these regs kind of clarified is, how does the eligibility provisions of a plan, how do they interact with this waiting period concept? And basically, if you have an hour of service requirement, if someone has to work for you, let's say 1,000 hours before they're eligible for coverage, the regs say that an hour of service requirement cannot be greater than 1,200 hours. Okay, that's one wrinkle. In terms, again, the waiting periods after eligibility, these regs clarified, well, how does an employer structure its eligibility provision so that it doesn't run afoul of the waiting period rule if it wants to use hours of service? And it says you can count hours as long as you don't exceed 1,200. Also, it's John's point about, and we already talked about it, but it's important to know that the waiting period rules specifically acknowledge and allow you to use this measuring concept for your new part-time and new variable hour and new seasonal employees. So if you comply with the measuring period rules that we went over, the waiting period rule, you will not violate those rules. Now, there's some wrinkles in if you stick to the example that we just went over with the 11-month measurement period followed by a 2-month admin period followed by a 12-month stability period, you will not violate there's a special rule tied to the waiting period rules that says you can't measure someone's hours for 12 months. A new hire, let's say you hired John, you measure his hours over a 12-month initial measurement period. You can't then add another 90-day waiting period at the end of that. So if you want to talk more about it, again, we'd be happy to discuss it with you. But if you stick to kind of what we put in that example, you should be fine. There's a special rule that's in these regs that's way more complicated than it needs to be, and we just tried to give you an example that you could use practically to be in compliance. One of the things that we wanted to mention, and this is not it's not in your slides, folks, but and kind of hinted at it at the beginning, and wanted to mention if we had a little time at the end. The reporting rules that just came out, there are two different reporting rules, and these people like me have kind of been zoned in on these player pay rules for some time because of we've had some proposed regs to work with. They issued the final reporting rules recently, and the two pieces of that, there are two different ones. Kind of the takeaway: if you have a fully insured plan, you will have to use a form to report both to the government and to your employees the coverage that you're offering to them. If you are self-funded, you will use that same form. You'll just complete a second piece to it. So good news for our self-funded employers that are listening. The reporting regulations have allowed a simplified method so that you'll be able to use the same form to report for both reporting requirements, or two different ones. Not going to spend a lot of time talking about those, but just know these rules are out there that you should be thinking about, and your consultants and your lawyers should be helping you get in compliance, because the concept is similar to the W-2 concept, the way you report your W-2s to your employees and to the government. and you need to have the mechanisms and the reporting systems in place way in advance of at the end of 2015. People ask, okay, that sounds cool, but when does it take effect? And the answer is the first reporting will be due in early 2016 for the 2015 year. And it's not, if you have a non-calendar year plan year, it doesn't matter. It's all on a calendar year reporting basis. So for the calendar year in 15, that's the first reporting year that these rules are going to kick in. And then you'll have to make the reporting in early 2016. These reporting rules are the mechanisms by which the government enforces all of these player pay rules we've been talking about. And they're critical. That's the reason they delayed the employer mandate before, because they didn't have these rules in place. Well, they have them in place now, so the likelihood of these player pay rules being delayed down the road, I think, is very slim.
And so that deadline, Brandon, is February 28th of each year is kind of the target.
Yes,
so they'll have to file that. And I think the form is Form 1095C, so they can be looking for that.
And I don't think it's out yet. Have you been able to find it?
No, not yet. We're just kind of tracking that.
Yep.
But if they want to pay attention to that, that's the form you're going to be looking for.
Okay, before we close, just a few quick reminders. Later today, you'll be getting a follow-up survey about this webinar. Please take a few moments to complete that questionnaire. Your feedback helps us improve our event, as well as letting us know what topics and issues you care about most. Also, as I mentioned earlier, once we get final approval from HRCI, we will send an email to those who signed up for HRCI credit at the time of registration, and that email will include the program details about today's webinar for recertification submission. And later this afternoon, an archived version of this webinar broadcast will be uploaded to our webinar resource page. That downloadable version of the presentation materials is also available there. You can easily access that resource page from the homepage of EmployerLink.com and MacPNTaft.com. I want to again thank Brandon Long, John Papahronis, and Teah Corley for presenting today's webinar. And on behalf of the law firm of MacPNTaft, thank you for joining us for another Employer Link webinar. See you next time and have a great afternoon.